Welcome to InstaLegal. Today's question is, what to do if non-bailable warrants are issued against me? Before we discuss this question, it is important to understand what is a non-bailable warrant. Usually it means that the person against whom such a warrant has been issued by a competent authority can be arrested on site for the particular purpose for which his presence is secured by the respective court. Now, the warrants can either be bailable or non-bailable, and usually they should not be issued without proper scrutiny of facts and complete application of mind due to extremely serious consequences and ramifications which ensue on issuance of any kind of a warrant. In a bailable warrant, whenever the police officer or any other person authorized to execute such a bailable warrant approaches you, there is a certain amount of money that you have to pay, which is basically called as a bail bond. And on payment of that, you're required to make an appearance before the court on the prescribed date. In a non-bailable warrant, you can simply be arrested on site without payment of any money, and you will be taken into custody, wherein you will have to be produced before the nearest magistrate within 24 hours of issuance of the non-bailable warrants. Now let us see under what circumstances the non-bailable warrants can be issued. It can be issued if it is reasonable to believe that the person will not voluntarily appear in court, or the police authorities are unable to find the person to serve him with the summons, or the person could harm someone if not placed in custody immediately. Although these principles are not exhaustive, but these need to be borne in mind while proceeding for issuance of a non-bailable warrant. A non-bailable warrant can also be issued if on pronouncement of conviction or sentence the accused fails to present himself, which is a mandatory requirement under the Criminal Procedure Code. Now, what are the steps that you require to take if you get to know that a non-bailable warrant has been issued against you? Section 76 of Criminal Procedure Code, it requires the police officer or other person who executes the warrant to bring the person arrested before the court within 24 hours. So the most important thing to do right now is, if you get to know that there is a warrant which has been issued against you, get yourself an advocate to represent you to get the warrants cancelled as soon as you get the knowledge of non-bailable warrants issued against you. Secondly, if you are evading arrest in a case where serious allegations are made and non-bailable warrants are issued and still you are nowhere to be found, the court will start proclaimed offender proceedings. Please understand, if a proclaimed offender proceeding has been started and you are declared a proclaimed offender by a competent court, then getting a bail will be the toughest point for you. If while on bail, the accused doesn't appear in spite of bailable warrants or the summons issued to him, the court may cancel the bail and issue non-bailable warrants, so never miss your hearing. So this is very important. There is a case of Raghuvansh Divanchad Bhasin versus State of Maharashtra. It has been held in that case that the power and jurisdiction of the court to issue appropriate warrant, be it a bailable warrant or a non-bailable warrant, has to be exercised judiciously, striking a balance between the need of law enforcement on the one hand and the protection of citizens from high-handedness at the hands of the law enforcement agencies on the other. Be that as it may, it is for the court, which is clothed with the discretion, to determine whether the presence of an accused can be secured by a bailable or a non-bailable warrant, to strike the balance between the need of law enforcement on the one hand and the protection of the citizen on the other hand. The power and jurisdiction of the court to issue appropriate warrant against an accused on his failure to attend the court on the date of hearing of the matter cannot be disputed. So if you have secured yourself a bail and you don't appear, or if you have not get yourself any kind of a bail, the challan has been presented, or even after the charge sheet has been filed or the charges have been framed and the accused have failed to appear before the court, to secure his presence can issue non-bailable warrants. even during the proceedings of a trial, if any witness who is not appearing purposefully, where certain information is specifically in the knowledge of that witness and the witness does not appear in such circumstances also, if after issuing of the summons or the bailable warrants, yet the witness does not appear, the court has the power to issue a non-bailable warrant to secure his presence for a particular point at a particular place. Thank you very much.